Good evening, everyone. I am Senator Roxanne Persaud, and welcome to our conversation this evening about estate planning. This is in partnership with Grow Brooklyn. Our panelist this evening is Charles Harris, Director of Legal Services at Grow Brooklyn Incorporated. I want to remind everyone that this is being broadcast live on Facebook, so you may join us on Facebook, and if you have any questions, you put the questions there, and the questions we'll try to answer as many as possible. If you're here with us on Zoom, you place your questions in the question and answer feature, and we will try to answer again as many questions as possible. So this evening, again, we are here to talk about estate planning. Charles Harris is the Director of Legal Services at Grow Brooklyn, where he leads efforts to provide free legal support to low and moderate income communities. He works closely with other HUD certified housing counselors to support foreclosure prevention, etc., estate planning, asset preservation for homeowners. He's presented on topics related to estate administration and housing stability. And this evening, as we've been advertising, this is a very important topic. Many people in our community are not aware of what estate planning is. And so this evening we have Mr. Harris here for us, and he is going to lead us through estate planning. So Mr. Harris, welcome to our conversation this evening. And if you would just like to say anything before you decide to start your presentation. Again, welcome and thank you for being here.
Certainly. Thank you very much, Senator. I'm going to share my presentation on the screen now. Okay. There we go. That should be visible for everybody. Okay, and I will get started. So again, thank you, Senator, for organizing this event and for having me here this evening, and thank everyone for attending. I strongly believe that no matter where you are in Brooklyn or in your life, that this topic will have something for you and probably also for other people in your family and your community. So my name is Charles Harris, and I'm an attorney at Grow Brooklyn, which is the name of my organization. Grow Brooklyn is currently providing free estate planning services. So that includes free wills and other documents that we will discuss today. In addition to our free estate planning services, Grow Brooklyn provides foreclosure prevention counseling and legal assistance, surrogates court legal assistance, and free income tax preparation. Please note that while our name is Grow Brooklyn, that reflects our location and roots, but our services are available throughout Brooklyn, but also to all New York City residents. So these are the topics for today. The presentation will take you through the various ways that you can prepare for becoming incapacitated using advanced directives and plan for the end of your life with estate planning. I will try to respect everyone's valuable time and keep it relatively short and sweet in the presentation so we can have some time for Q&A. Again, while I hope there is a lot of valuable information that everyone will get out of this presentation today, my goal is equally to raise awareness as much as possible that everyone should speak to a professional about estate planning, no matter what assets you may own at the time, whether you're a homeowner or not, no matter your family situation, if you have children of your own, and to raise awareness also that it's not just who will inherit your assets, but also who can act for you and speak on your behalf, even in cases where you're still alive, but you can't, for whatever reason, mental incapacity, for example, make decisions, communicate, sign documents, etc. So today, I hope that everyone comes away from this presentation thinking that if they haven't already, that they should talk to a professional about these things, and that many of these things can be done for free, and that we here at Grow Brooklyn are indeed an organization that provides these services and provides them at no cost. So getting into the actual substance of our presentation today. The importance of developing incapacity in estate plans. So incapacity planning allows you to retain control over your decisions and assets, even after you're no longer able to communicate. By signing certain documents, you can appoint a trusted person to make decisions and act on your behalf. And you can even make certain decisions for yourself in advance. Without an incapacity plan, New York state law and the courts will determine who can make decisions for you, and that person may not know your wishes or may fundamentally disagree with them and make decisions for you that you would never have made for yourself. Similarly, estate planning allows you to retain control over the distribution of your assets after death. And without an estate plan, New York state law determines which of your blood or legal relatives will receive your assets after death. Advance directives are documents which allow you to appoint agents to speak and act on your behalf while you are still alive. The most powerful of these documents is the power of attorney. A power of attorney allows you to appoint an agent to make designated financial decisions on your behalf while you're still alive. You can narrowly tailor the authority that you grant your agent, such as signing a deed for a closing that you can't attend, or grant broad powers to your agent so that they can make decisions on your behalf of any kind, including buying and selling property, investing your money, purchasing life insurance, and opening and closing bank accounts. So why should you sign a power of attorney? In the event that you become incapacitated, you're going to need someone to speak to insurance companies, sign checks from your accounts to pay your bills, transfer money, and otherwise manage your affairs. Your agent, if you give them that authority, will be able to do all of those things for you. When does a power of attorney go into effect? There are two different types of power of attorney, a durable power of attorney, and the other one is a springing power of attorney. A durable power of attorney is effective as soon as it is signed by both you and your agent before a notary. A springing power of attorney is triggered by a specific event. Usually that means when you become incapacitated. Some people believe that a contingent or springing power of attorney is appropriate for their needs. While this may sound ideal in theory, in practice, most people who would have to rely on your power of attorney, be it a bank, a mortgage lender, or an insurance company or otherwise, would not accept a springing power of attorney without a court order determining that you are indeed incapacitated. We typically advise against using a springing power of attorney. When does a power of attorney terminate? Your power of attorney terminates upon your death, or if you revoke it in writing and the revocation is delivered to the agent. However, that isn't the end of the story. You'll have to deliver the revocation to each of your financial institutions, as they will have no knowledge of your revocation and will continue dealing with your agent until advised otherwise. What is your agent authorized to do? So you can grant your agent as much or as little authority as you want, including but not limited to banking transactions, property transactions, operating a business, participating in litigation, healthcare billing and payments, but only billing and payments, not health decisions. We'll get to that later. Also, other transactions, including retirement benefit transactions, tax filing, etc. So for clients who are preparing powers of attorney for potentially becoming incapacitated, we often recommend granting full authority. Where will the power of attorney be accepted? Institutions in New York are required by law to honor a power of attorney prepared using the New York statutory short form. However, it may not be accepted by institutions outside of New York, as powers of attorney are governed by state law. Who should you appoint as your agent? Someone responsible who you trust completely. Depending on the authority that you grant, your agent may be able to essentially assume your identity for all financial transactions, and your agent could transfer your home to themselves, take out a mortgage on your home, drain your bank accounts, or even change the beneficiaries on your life insurance. Now, you are able to appoint co-agents to provide some checks and balances, but they would have to cooperate with each other, and anything that they sign will have to be signed by both. Disagreements or logistical issues could result in your affairs not being managed, and we typically advise against co-agents. However, you can also appoint a successor, which is the same as a backup agent, who can step in to act as your agent in the event that your primary agent dies, becomes themselves incapacitated, or declines your grant of authority. How do you execute a power of attorney form? Both the principal and the agent must sign the power of attorney, and both signatures must be notarized. The principal's signature must be accompanied by the signatures of two witnesses who are people who have no interest in your estate when you pass away. The agent can sign at a later date, but the power of attorney doesn't go into effect until the agent has signed and has their signature notarized. And at the bottom, limitations: your agent cannot make medical decisions on your behalf. To appoint someone to make medical decisions on your behalf, you need to sign a document known as a healthcare proxy. A healthcare proxy allows you to designate an agent to make medical decisions on your behalf, but only if you are not able to make those decisions on your own. Now, the term healthcare proxy is used both for the document that you sign designating your agent and the agent themselves. So I sign a healthcare proxy to name Joe Smith as my healthcare proxy. In the absence of a healthcare proxy, the New York Family Health Care Decisions Act dictates who will make your decisions for you. In order of priority, your healthcare decisions will be made by a legal guardian, spouse or domestic partner, adult child, parent, sibling, or close friend over the age of 18. So the kind of situation where this might arise, for example, you may recall that many of the patients admitted to the hospital due to COVID-19 were placed on ventilators and put into medically induced comas. During that time, any medical decision that the patient would have made would be in the hands of their nearest family member. And the person that the doctors speak to may not know all of the patient's wishes, or has been the case in the past, may not agree with their wishes or impose their own. If the patient had signed a healthcare proxy, those decisions are now solely in the hands of a person that the patient trusts, not necessarily the person who is first in priority by law. Unlike a power of attorney, the healthcare proxy will only be honored after a healthcare professional determines that you are incapable of making your own medical decisions. Healthcare proxies must be signed by you and 2 witnesses who have no interest in your estate. None of the signatures need to be notarized. It is a good idea to give a copy of your healthcare proxy to your agent or agents and all of your healthcare providers. Your agent should be someone who you trust and who knows your healthcare wishes, as all of your decisions will be up to their discretion if you become incapacitated. However, you can specifically state your wishes regarding certain healthcare decisions using a living will. So a living will allows you to state whether you wish to receive certain medical treatments. Typically, these are used in the case of terminal illness or incapacity with no chance of recovery, in which you can express your desire not to be placed in a feeding or breathing tube, or to receive maximum pain relief, even if it may shorten your life. The living will and healthcare proxy work together to ensure that your healthcare wishes are honored, even if you're unable to communicate with the doctors. If you have a living will, that should be noted in your healthcare proxy. We typically attach our living wills to our healthcare proxies directly. Living wills are signed the same way as healthcare proxies, with 2 witnesses who have no interest in your estate. So now that we've gone over all the documents that can help you prepare for issues that may occur during your life, we can move on to estate planning. What happens to your assets after you die? Upon your death, any assets that you own that did not have a joint owner or death beneficiary become part of your estate. So if your name is John Smith, your assets now belong to the estate of John Smith. These assets, be they bank accounts, homes, vehicles, or any other assets, cannot be withdrawn, sold, or transferred until someone is appointed as the representative of your estate by the surrogates court of the county where you lived. The surrogates court is the name for the New York State Court, which primarily handles estate matters. Now, some of your assets will not become part of your estate. Anything that you own jointly with the right of survivorship, such as a home in some cases, a vehicle, bank account, will automatically become the property of the joint owner upon your death. Similarly, any account where you have named a death beneficiary, such as a life insurance policy, bank account, or retirement plan, should be paid out to the beneficiary by the financial institution upon proof of your passing. Your estate representative is responsible for gathering all of your assets, settling your debts, litigating any claims you may have had or others may have had against you, filing your final tax return, and once that is all complete, distributing your assets. Minors, convicted felons, and persons who lack mental capacity are ineligible to become estate representatives. If you die intestate or without a will, New York state law dictates how your estate will be distributed to your family, and any one of the family members eligible to receive an inheritance from your estate is entitled to petition the surrogates court to be appointed as the estate representative. The person appointed as representative of your estate when you don't have a will is called an administrator, and the surrogates court proceeding is called an administration proceeding. New York state law dictates that your estate will be distributed as follows. If you are survived by a spouse and no children, your spouse receives your entire estate. If you are survived by children but no spouse, your children receive your entire estate in equal shares. If you are survived by a spouse and children, your spouse receives the first $50,000 in value of the estate and then half of the remainder. And your children take the other half of the remainder in equal shares. So the easiest example for this is as follows. Say that you are survived by a spouse, Sam, and 3 living children, Alex, Bobby, and Charlie, and you own $50,000 in an individual bank account and a house in your name alone when you died. The most sensible distribution of this estate is that your spouse directly receives the $50,000 from the bank account and half of the ownership of the house, and each of your 3 children receives a third of the other half of the house, or 1/6 each. If one of your children dies before you, but leaves behind grandchildren, those grandchildren will split their parents' portion. So say Charlie passed away before you, but leaves behind 2 adult children, Dylan and Ellie. Dylan and Ellie split Charlie's portion of your estate. If you are survived neither by a spouse nor children, your estate will be distributed to your parents. And if they have not survived you, then your siblings, and so on and so forth, as the classes of your family become more and more remote. The result of this is that all of your worldly possessions may end up with family members that you don't know at all. The members of your closest living family class are referred to as your distributees, as your estate will be distributed among them. You should be aware that the law will distribute your estate without any consideration of your family dynamics. A child who you have not spoken to in 20 years, and a child who has financially supported you for the past 10 years and perhaps lived with you will receive identical portions of your estate if you don't have a will. You should also be aware that under New York state law, stepchildren, which you have not legally adopted, and children you may have raised and treated like family but have not legally adopted, receive no inheritance from your estate. Again, it does not matter that you consider this person a part of your family, or that they reside in your home and received or provided you with care, or that the entire family or community perceive them as such. Without a legal relationship, they are not entitled to any portion of your estate. Additionally, New York State does not recognize common law marriage. So a romantic partner who you lived with for over 50 years but never married would not be entitled to receive a portion of your estate. Finally, domestic partnerships are not recognized under laws governing estates. So even if you have New York recognized domestic partnership, your domestic partner does not receive anything if you do not have a will. If you would like to retain control over who receives your estate, you should prepare a will. If you die testate, meaning that you died with a will, your will dictates who receives your property after your death and who will be the representative of your estate. It can also declare who takes custody of your minor children. The person you nominate to be your estate representative is called your executor, and your executor is responsible for carrying out your wishes as you stated in your will. However, while you can draft your will as you see fit, distributing your assets in varying amounts or percentages to your family and friends, New York state law will not allow you to write your spouse out of your will. And again, will not allow a minor convicted felon or person who lacks mental capacity to be your executor. Many clients ask if their executor can avoid surrogate's court by having a will. Unfortunately, they cannot. Your executor will have to petition the surrogate's court to approve your will and their nomination as executor, and they don't have any authority to handle your estate affairs until that petition is approved. This proceeding is called a probate proceeding. When drafting your will, you should be prepared to answer 3 important questions. The first is, what do you own and how do you own it? As stated earlier, jointly owned assets and assets with death beneficiary pass directly to the co-owner or beneficiary and do not become part of your estate. So these are known as non-probate assets. All other property that you own stays there though and becomes part of your estate, and these are referred to as probate assets. It is a good idea to have as few probate assets as possible, as your beneficiaries will be able to access the non-probate assets much more quickly and cheaply. If you own real property or real estate, it is important to know how you own that property. If it is owned individually, the property will become part of your estate as a probate asset and cannot be dealt with until your executor is approved by the surrogate's court. If your property is owned with others, the language of your deed determines how that property is owned. And there are three forms of co-ownership. The first form is called a tenancy in common. You and your co-owners each own a percentage of the property, which you can sell and transfer as you please. Upon death, your percentage becomes part of your estate and your co-owners' percentages remain with them. The second form of co-ownership is joint tenancy with the right of survivorship. Here, you and your co-owner each own 100% of the property, and upon death, your co-owner remains as the sole owner of the property. That's the right of survivorship. The property is a non-probate asset and does not become part of your estate. The third form of co-ownership is tenancy by the entirety. This is very similar to joint tenancy. Tenancy by the entirety features a right of survivorship, but it is only available to married couples. If a married couple purchases a property and their deed is silent as to their form of ownership, then they do own as tenants by the entirety. The difference between joint tenancy and tenants by the entirety has no bearing on estate planning, so I won't be addressing it here. What you need to know for estate planning is that when one spouse dies, the surviving spouse becomes the sole owner and the property does not become part of the deceased spouse's estate. Cooperative apartments present a unique issue in estate planning. When you own a co-op, you don't actually own the physical apartment. As you probably know, you own a number of shares in the apartment corporation, which entitle you to a proprietary lease for the apartment, which was approved by the board of directors of the apartment corporation. While you may wish to leave your apartment to a friend or a loved one, simply stating that in your will does not mean that that person will be allowed to live in the apartment. Transfers of co-op apartments are subject to the restrictions stated in the cooperative offering plan, the rules which were established by the board of directors, and the terms of your proprietary lease. Some co-ops give their shareholders the right to transfer their apartments freely to a spouse or child. Others may retain the power to reject your beneficiary if they do not meet the board's standards for new purchasers or do not intend to reside in the apartment as their primary residence. In this case, the apartment will have to be sold and your beneficiary will be entitled to the proceeds of sale. I'd like to briefly go over the capital gains tax implication of estate planning, specifically for any real property you may own. And the reason for this is both because a lot of money is at stake and also because title can be transferred very easily between family members and the implications may not be known. They can be very, very enormous. So for example, I'm going to make an example where you bought your house in the 1960s for $50,000 and you sold the house today for $950,000. First of all, congratulations, you have made $900,000. However, your initial purchase price of $50,000 is your tax basis, and you have to pay a capital gains tax on the $900,000 of profit that you made on the transaction. If you use this house as your primary residence, you may be entitled to exclude up to $500,000 of that profit, but in any event, the sale will still be heavily taxed. However, if you pass away today and your house is transferred to your heirs, they would receive what is known as a step up in basis. Their tax basis would be set at the value of the house on the date of your death. So in this example, $950,000 and no longer $50,000. So at $950,000, if they were able to sell it shortly thereafter, they would likely pay little or no capital gains tax at all. So again, we bring this up because we've had clients ask about avoiding probate by simply transferring their home to their heirs while they're still alive. If you do that, your heirs' tax basis in the home is your $50,000 purchase price. So using the previous example, if you deeded your house to your heirs yesterday, died today, and your heirs sold it tomorrow for $950,000, they would be responsible for paying capital gains tax on $900,000. And if they don't use the home as their primary residence, they won't be entitled to any exclusion and will be taxed on the full amount. So again, going back to the three questions, what do you own and how do you own it? The second question is, who do you want to inherit your possessions after you are gone? So you are under no obligation to leave your estate to your children, nor are you under any obligation to divide your estate equally. The only thing you can't do is completely write your spouse out of your will. If you're married at the time of your death and you have not entered into a legal separation agreement and you have left your spouse out of your spouse is entitled to either $50,000 or a third of the entire estate, whichever is greater. If you do intend to write someone out of your will, they may contest the validity of the will, which can result in the estate being stuck in surrogates court litigation for years with no representative appointed, while the assets sit or possibly begin to waste. There are competing theories about how to write someone out of your will. Some attorneys recommend affirmatively stating that you leave nothing to my child so-and-so. Others recommend giving the child you intend to leave out a nominal gift of a few $1,000s and inserting a clause that states that anyone who contests your will receives nothing. However, the nominal gift should probably be large enough to make the no contest clause actually worth something. So if you have a $500,000 estate and two surviving children, if you give one child $5,000 and the other $495,000 with the no contest clause, the child you intend to write out is likely going to view their $5,000 as an acceptable risk to contesting the will, as if they're successful to their will contest, they will receive a windfall of $250,000. The third question is, who do you want to appoint to make sure your wishes are honored? Your executor should be someone who is trustworthy, responsible, and competent to navigate the surrogates court probate process, or at least competent to work with an attorney to do so. People often choose one of the main beneficiaries of their will. It is a good idea to choose someone who is local, although that matters less and less these days with all the remote options. But still, local is helpful and also will be able to care for your assets, deal with local attorneys to provide them with documents, and if need be, also to appear in court. You can name co-executors and successor executors. We typically advise against naming co-executors in simple estates, as co-executors must agree on all actions pertaining to the estate and will need to co-sign most documents. Each executor is entitled to their own attorney, which is paid for by the estate, and each executor is entitled to be paid a commission, which is a percentage of the value of the estate. So double the executors, double the cost for the estate's attorney fees, and double the commissions. We do, however, recommend naming a successor or backup executor. This is a person who will step in as executor if your primary executor is deceased, disqualified, or declines your nomination. Executing a will. So once you have established what you own, who will receive it after you pass, and who will be responsible for distributing it, the next step is to execute or sign your will. So some quick terminology here. You, as the person whose will this is, are referred to as the testator. If this were your last will and testament of John Smith would be the testator. In order for your will to be valid, you, the testator, must be of sound mind in the moment that you sign. You must be able to identify your will and understand what the will does and the significance of signing the will. So you can suffer from dementia when you sign your will, as long as you are in a lucid period. However, of course, executing a will after being diagnosed with dementia could give one of your heirs, particularly one who is receiving a smaller gift or no gift at all, an avenue to try to have your will invalidated after your death. Your will must also be signed by at least two witnesses who are not beneficiaries of the will. While having a beneficiary serve as one of your witnesses will not invalidate the will, it is very likely to invalidate that beneficiary's gift. Most attorneys use people who work in their office to witness wills. Your witnesses must be of sound mind and be able to attest that you signed your will. Most wills are accompanied by a self-proving affidavit. This affidavit is a sworn, notarized statement signed by your witnesses and stating that they witnessed your will and details the circumstances of your signing. Having a self-proving affidavit makes it much easier to probate your will in surrogates court after you pass away. Without it, your executor would have to find your witnesses and have them sign affidavits to submit to surrogates court after your death. Your will does not need to be notarized, but the self-proving affidavit does, so it is a good idea to have a notary present when you sign your will. Safekeeping. So now that you've signed your will, what do you do with it? You should keep your original will somewhere safe where it cannot be damaged or marked. It will likely be stapled. Do not remove those staples. Removing staples can raise the implication that the will has been tampered with. Your authorities should provide you with an additional copy of your will, which you can use to make further copies. Your executor should absolutely receive a copy of the will and should be made aware where the original is located and able to access it, as they will need to submit the original to circuits court after your death. This means that a safe deposit box or a fireproof safe is a good idea, but only if your executor has access. You should also let your beneficiaries know that you have a will, where it is, and who the executor is. There is no requirement that you give a copy of the will to your beneficiaries. That is a determination you can make on your own based on the dynamics of your family. If the original will cannot be located, it raises a presumption that you destroyed it with the intent of revoking it. This presumption can be overcome, but it is very difficult. So what do you do if you want to make changes to the terms of your will? The only way to change the terms of your will is to execute a new will or a codicil, which acts as a supplement to your original will. Codicils are extremely rare, as it is now easier and less confusing to just sign a whole new will. You should never make handwritten changes to your will. Handwriting changes to your existing will have no effect, but enough handwritten changes could serve to invalidate the entire will, and your estate will then be distributed in accordance with the rules of intestacy under New York state law, which I reviewed earlier. Okay, so it now being 6:30, that's the end of the formal presentation, but I am here to answer questions. I'm putting up the contact information for our organization on the screen here. And again, we do encourage you to reach out if you have any questions at this contact information. Our estate planning for all of these documents is free. We provide free legal services. So I guess I'll turn it over to the senator, I believe.
Well, thank you. Thank you very much, Charles, for all of that information. It is quite informative. We have a number of questions for you. And so I am going to try to have you seen the questions that are there? I'm going to read some of them and then you can answer that. What happens if someone dies and they're in the midst of a divorce? What happens?
Well, typically, if the divorce hasn't been finalized, they will still be treated as a spouse for the purposes of if there is a will or if there isn't a will, your status as a spouse does entitle you to a portion of the estate. And so it's very important to highlight that, we do have certain clients who may have been separated from their spouse for many years, may not even know where they are. Maybe it's been decades, but without a formal divorce decree, for inheritance purposes, they are still entitled to half of the estate, or at least a third of the estate, even if they're written out of the will.
Thanks for that answer. And then there's another question. Can the person holding the power of attorney have an interest in the estate?
Absolutely. It's very common for, I would say a majority of the time they probably do based on our clients. So it's very typical to even do a power of attorney to your spouse, who's generally will have interest in your estate, or just as often to one of your children. So that's very common and not seen as a problem.
Okay. So there's a comment that someone placed here. First, they want to know how is capital gains calculated, and then there's also the comment that capital gains taxes should be for property over 2 million because most property is over 1 million, which is not actually so. So this law is old. Yes, the law is old, but there's property that's not. So can you tell us how capital gains are calculated?
Probably not. I can't, I really wanted to get into that example because I do have a general sense of it, mainly to, um, raise the awareness or raise an alarm of kind of, to not treat lightly transferring a deed because it's pretty common for parents to transfer the deed to their children while they're alive because that would smooth out the inheritance process, possibly avoid probate. And it's just important to be aware that there is a loophole or an exception in capital gains taxes that a property that's passed down through death can avoid a lot of money in property taxes. But you should definitely, for anything more detailed or personal or complicated, you should discuss it with a tax professional, which we are not.
Thank you. There's another question. What happens, there's a couple and the person, one spouse dies, but the other spouse was never placed on the deed for the property. And so does that spouse automatically inherit the property?
It depends on the family. In other words, if there are children. So if there are no children, then the spouse will inherit the property. It's a little messier or time consuming than if they were just both on the deed to begin with. But it does happen. And so they will just inherit the property. If there's a spouse and children, then that's a big difference because if they were both in the deed together, the surviving spouse would own solely. However, if there's surviving spouse and children, then the property gets split up, half to the spouse plus 50,000, and the rest equally to the surviving children. And these are simple examples. Sometimes people live long enough, they might have a child who unfortunately passes away, leaving their own children, and then you've got those children step into the shoes of their parent.
Okay. How does the state determine closest family member? Is there proof of the living spouse had abandoned the deceased when the person was alive, obviously?
Can you, so the question is, how does the state
determine closest family member?
Right. So they have what are called classes, which they kind of go through and they get more and more remote, but they're pretty thorough. So, again, as I stated, you've got spouse and children. If those don't exist, then you have to look to parents. If they're deceased, then all the descendants of your parents, meaning your siblings, nieces and nephews. None of those, then you go to your grandparents. And assuming they're deceased, then all of their descendants. So now that, the family tree can get more and more remote, and you can start talking about people you may not have ever met, know where they are, or even know that they exist. And so that is something to keep in mind. I want to highlight that even if let's say that's your family situation, for whatever reason, you only have distant relatives. So fine, you make a will leaving everything to somebody you raised as a child but never adopted, or your best friend. You can do that, but when that will is taken to probate, whoever those distant relatives who are now being disinherited have to be notified. So that's always something that, the probate process can be a little bit difficult and time consuming and messy because you might have a very simple will, but if your family tree is complicated, or if your surviving surviving heirs are very distant, then those have to be identified and notified. And then, that can sometimes, just the process of finding them can take a while. Or if they are found and they feel like it and it's worth it, they may try to contest the will. And even if they have not a very good case, that can still slow things down quite a bit, and require the hiring of an attorney if you don't already have one. So, yeah.
So this is another part of the question. So if a spouse had abandoned the person, the deceased person now, they had abandoned, they had no contact, Is there a way that if you prove that person does not get any of the inheritance?
Um, if the person is asking about a specific situation themselves, I definitely encourage them to reach out to us. Um, Generally, there may be principles of abandonment that may be established to show that they should not get an inheritance. And again, you can reduce your spouse's inheritance in a will from half down to a third, but they still have the right to that third. And so the problem is one of the things about doing a will is the only really the only time you don't know how good it is until it's brought before a judge for probate. And at that time, you can't make another one because that means you've already passed away. So it's hard to guarantee that if that you can disinherit somebody just based on a very strong case of abandonment or something like that.
Okay. I just want to remind everyone who's on Zoom, or if you're on Facebook, if you're on Zoom, place your question. Someone is asking, may I ask a question? Please place your question in the Q&A and we will read that question. If you're on Facebook, you put it in the comments and the staff is going to share it with us and we will ask that question on your behalf. There's another question I'm going to see. This here is in the Q&A and it's from one of our anonymous attendees. How can we protect inheritance from how can we protect inheritance for beneficiary with slight mental incapacity, but is an independent adult? How do we set up the inheritance to be managed by a capable sibling?
So your wills can be drafted in all kinds of different ways. Sometimes what wills can do for cases where you might have child or a beneficiary with some sort of capacity issue, or maybe they're just a minor. They're not, they haven't reached the age of 18 or 21 or whatever the will says they need to reach, at least 18, then wills can establish, in certain events, they can establish trusts, which can then be administered by whoever you've appointed to administer those trusts. So a trust can be established through a will, and it sounds like in that example that might be how you would choose to draft it.
Okay. So here's another question in the Q&A, and that is from Lorette. It's how does it work for an only child, single, no children, to leave the estate? They leave the estate to several charities.
Yeah, I mean that apps anybody can leave an estate to charities. You can leave part of your estate to charities and part to family members. So again, I think that might go back to what I was mentioning about if this is a person who has no immediate or known family members, they can absolutely do that. And then, it always helps to try to, instead of giving that job to your executor after you pass away to find out who your nearest relative is, maybe you can start the process a little bit yourself to see if you can find out who that is. And I'll use this opportunity to say, that's the probate process. And the probate process it's in surrogate's court. It's when you're taking the will to probate. It has a long tradition, and that's what happens to wills. If they are needed to, if there's property in the estate, they go to probate, and that means that any heirs or distributees must be notified that there is a will, that maybe they're being disinherited. They have the opportunity to come to court, to contest the will, to contest the appointment of the executor. And so they have to be identified, as I was saying earlier. So these are all things that even if the will is perfectly written, it's ironclad, and it's very difficult to contest, just the fact that they might need to be identified, or they're hard to identify, or they're hostile, it can definitely make it to be a long process. Surrogate's court in New York City, definitely in Brooklyn, they're not, they take some time to process even simple cases. So that these things can get bogged down for years even. Again, even if the contest doesn't have a lot of merit. And so what some people end up doing is they say, how can I avoid probate? Is there a way that I can pass this down to who I want to pass it to, my family member, or even to charities, without the need to make it go through surrogate's court or the probate process? And so one way, again, I mentioned just transferring a home to a family member. Be very careful about doing that. It's very easy. People can even do it without attorney. They can, go to the city recorder's office. It's very easy to do a deed, but the implications can be huge. It could be worth tens of thousands of dollars or more. So they might do it with a simple deed transfer. There are other kinds of deeds. There are things like life estate deeds where you may deed a property to a family member while retaining. I guess this doesn't go to the charity question, but for anybody thinking about family members, that you own that the property you deeded to, say, a son, and retaining a life estate for yourself as long as you live there. And then when you pass away, then they become the sole owner. There's now a new deed from 2 years ago now that it's existed all over the country, but this is a matter of state law and it never existed in New York before. But it's a transfer on death deed where, kind of like a bank account with the beneficiary, not quite so simple, but that's the idea, where you have a deed in your name with a death beneficiary. And so when you pass away, that property goes to whoever you say it goes to. These are all ways of getting around probate. And of course, another huge one is trusts. You make a trust with an attorney. We don't do trusts at this time, at least. It's something that may happen in the future, but as of today, we don't do trust. We can talk about your situation. We can see if that might be appropriate for you. But at the end of the day, we couldn't actually do that service for you. And so a trust is another way to avoid probate. You put your assets, namely your home for many people, into the trust after you've made it. And then after you pass away, nothing has to go to surrogate's court. Probably you just look at the trust. It's not even made public. It just, the property passes according to the terms of the trust.
Okay. And to create a trust, you must have an attorney. You can't just create it on your own.
Yeah, I would strongly recommend it, as strong as I could. Yeah.
Okay. And someone is asking about fees. Are there like standard fees charged for doing a will? And if you want to do a will, what documents would you need to bring?
Well, so if you're doing a will in the state of New York and you go to an attorney, it's definitely going to be a few $1,000s, I think, in most cases. I'm not totally caught up. Again, we do them for free. I think we're not the only ones. There's a few different organizations that do them for free. So you can always call 311. And I think these days, didn't used to be the case, but now you can call 311 and you'll be connected to us, or you might be connected to one of our partner organizations to do your will. And again, we're free. Have to bring a photo ID. That's generally, we might ask for a few other documents if you own property, or if there already is a trust or something. But no, just photo ID would be the document you would bring to our office.
When someone is coming to do a will, you're saying, okay, just bring, tell us you own property. What proof do they have to bring to show that the property really is their property that they're putting in the will?
We never have made anybody prove that they own property. One of the main reasons is that so we do have clients with property outside of New York City, of course, and elsewhere in the state, somewhere else in the United States, somewhere out of the country. And they don't have to prove that to us. And then New York City property is easily, we can identify it online. We can just see who owns it. I can, that sometimes I was mentioning earlier how you own your property, different forms of joint ownership. Sometimes people come to us, and one of the things we can discuss with them is the way that they own their property, because that's all available publicly online. Yeah.
Someone's asking, can you add a family member to current co-op property lease? So you're preparing your, you know, your estate, getting all your everything in order. Can you add your family member to that
So
process?
yes. So, co-ops they're their own animal. And so you have to, really they're viewed as, I think homes in general are viewed both as, of course, a home, a place where you live, or that you want your family to live after you, and a store of wealth. And that's kind of what a home, those are two ways of looking at a home. With a co-op, they kind of, it's the same, but it's split up. So you've got it kind of split into two different sort of documents. And so you can transfer, when you can leave somebody your co-op in your will, and they will definitely be able to uh, profit from the value of it. The question is whether they are able to have the right to live there. And that's something that isn't governed from the will, but it's governed by the co-op's governing documents about who they allow to inherit units. So that all depends.
Okay. So I'm not sure if I asked this question. Can the child of a living spouse who's not the child of the deceased claim their parents' share of the estate? The living spouse is in a nursing home. So can that spouse's child claim the estate for, on behalf of their parent?
Right. So this doesn't sound like a hypothetical, so I definitely encourage you to call us. It sounds like a real thing, but um, so again, I'm going to say it again to make sure that everybody is seeing it the way I'm seeing it. But again, you've got a married couple, one of them passes away, but that parent actually is not the parent of this child. That child is the son or daughter of the surviving spouse who is
Mhm.
in a nursing home. So, I mean, we see a lot of, some of the tricky issues come up with blended families. In other words, you've got two parents or two spouses who don't have exactly their children. It might be a little different. One might have one other child, or they could each have their own children, not together. Um, so, you know, the that child in that example sounds like they would not have any right or any inheritance. Although it's also common when spouses get married and there's already children from other um, from other parents, they might adopt the person. So I think it all depends.
Okay. So someone is asking, this is not a mental health, how do we protect inheritance for a beneficiary with a slight mental incapacity? I think we touched on that also.
That sounds like it sounds like the same question from before.
Yeah.
Yeah.
So can a surviving heir sell their interest in the estate? For example, a brother and I, and this brother and two siblings actually, are the living heirs, and the sister is now moving forward with selling the property. Can the one sibling sell their interest in the property to an investor or someone else? That sounds complex.
It does. And I can try to answer it. I would definitely contact us. I don't want to give too specific advice because it's happened before. I think a lot of probably everybody here is from Brooklyn, and we do have a lot of people call our office. So, we sometimes speak to people even that come up in these examples. So I don't want to provide too direct advice, but generally, what happens and what can cause problems is a home, may for what there may be five kids, six kids, or three kids, and people are just aren't on the same page, or maybe not everybody lives in New York City, or different people have different ideas about how they want what they want to have happen to the home, and investors see this, especially with the wealth in these houses, or some predatory actors might see a great opportunity. They might find some relative who isn't even aware of the situation, and they might, here's a quick $10,000 for your share that might actually end up being worth much more, and they might not even really understand the significance of what they're doing. So I would just advise that whoever is asking the question speak to somebody about this situation. In addition to this answer I'm giving now, you can call us or an attorney.
Okay, so our time is winding down, so I just want to do a couple more questions. Can a will be probated if you're unable to find an heir who is in the will? Will the court probate the will and set aside the amount that was willed to the missing family member?
After a very long and exhaustive process, then yes.
Can you say that last part? After a long and exhaustive process?
Ultimately, yes, that is what happens. So out of concern for the heirs that can be found and are eager for their shares, then I believe that can happen.
Okay. And someone is asking, how difficult would it be for someone to change their power of attorney? Do they need the previously assigned person to sign off on another document?
Right. So, yes.
So you're revoking it, so yeah.
Yeah, exactly. And so I think, as I said earlier, you know, if you give power to an agent through a power of attorney, they can't just do whatever they want. They're supposed to do everything at your direction, or according to what you wanted. And so the problem is that's pretty hard to enforce sometimes. So not only that, but you know, banks, financial institutions, other organizations, they might be pretty strict with the power of attorney that they'll accept. However, if you do want to revoke it or change it, it's very important. Any institution that you deal with, your mortgage company or your mortgage servicer, your bank, uh, anybody else, you can't tell the whole world. There's nowhere to record it. There's nowhere to tell everybody, but at least you can tell them that you've revoked your power of attorney or you have a new power of attorney. However, that the person you've given it to, they're still, they still have a duty, an obligation, uh, a fiduciary duty to you. Yeah.
Okay. Let's see the final one. Okay, we did the will, what fees are charged, what documents are needed. What happens, well, this trust, you said for people to contact, you guys do not do trust. And the final question, again, if I think a number of people are asking this, what's the best way to transfer your home to your children in order for them to pay the least taxes?
Yeah. I mean, it depends. You can, I would give us a call. Really, it's very hard to give general legal advice to a group of people, especially when it comes to such important questions, and not, you know, you don't want to be misleading. And so the main reason I did mention the capital gains taxes is we do see it. We see, of course, after the fact, we see that, oh, my mom transferred this deed to me, and then you can see that now they missed out on that exception. And if they had only spoken to a professional or an attorney, that might have been avoided. And so there are ways to transfer your property and benefit from the step up in basis, which is what you want. You want the basis to be as high as possible. There are ways to do that. You might do it with a life estate deed, or you might do it with a transfer on death deed, although, the law is still being created for that because it's such a novel instrument. But there are ways to preserve that step of basis Of course, obviously with a will or a trust, that'll be preserved too. But even if you do transfer the property during your life, there are ways, but you should speak to somebody before you go and do it and I say that because you can go down and do a deed very easily without an attorney, and that will have binding legal impact, but it doesn't mean you shouldn't have an attorney.
Well, thank you. This final question, if you are able to give the answer, what is the difference between an irrevocable and a revocable trust?
Okay. Probably not very satisfyingly, I will only be able to give the very obvious answer because each of them are kind of shorthand or maybe a lay person's term for many different kinds of trusts. There's many different kinds of trusts. The non-satisfying answer is that one you can revoke and one is very difficult to revoke and one is very easy. Oftentimes, irrevocable trusts are made a lot of the time for Medicaid purposes, and irrevocable trusts are often to avoid probate, although irrevocable trusts can do that as well. But yeah, so that's my answer on that. It does depend.
Well, thank you. Our time has come to an end. I want to say thank you very much for this informative webinar on estate planning. I know it's short. Many people still have questions, but I want people to be able to contact Grow Brooklyn if you have questions. If you want to make an appointment, the contact information is on the screen. We will have this information shared on our pages also, and it will be included in our weekly e-newsletter that will be going out tomorrow. So if you have a question or you'd like to meet with someone at Grow Brooklyn regarding estate planning, please contact them at the information as listed, and they will be glad to set up an appointment with you and tell you what you need to bring in for your appointment. Whether, the question there, what is it you need to bring in if you're coming to have a will done, anything you need the question answered, please call them and they will be glad to assist you. I want to say thank you to Charles Harris for being our partner this evening from Grow Brooklyn. We endeavor to bring information to the community because we know this is information that benefits everyone. People are asking for this information and you ask for it, and we try as best as we can to provide you with the resources that are available to us and that will benefit you. So I want to say thank you again to Charles. I want to say thank you to Michelle and Dennis, who are in the Albany office running this webinar and the Facebook and making sure that we see as many of the questions as possible. And I want to say thank you to everyone for joining us, whether you're here on Zoom or whether you've joined us on Facebook. Thank you, and I hope you've gotten all of your questions answered and that this webinar was informative. Please, again, if you need additional questions answered, please contact Grow Brooklyn, schedule your appointment. If you need assistance with setting up a will, etc., please contact Grow Brooklyn at the information on the screen. Again, we appreciate you, and we will see you at our next webinar, which is tomorrow at 1 p.m., where we're going to be talking women's health. So have a great evening, everyone, and thank you for joining us.